We have two more groups that would like to testify, and they're couples. So I'll call upon Jonathan and Rebecca Murray. And we thank you for being here. Good morning.
Good morning.
Morning.
I don't think we'll make y'all separate.
Okay.
Take these off. Good morning, Senators.
Good morning,
My
sir.
name is Jonathan Murray. This is my wife, Rebecca.
Can you pull the microphone a little closer to you so we
Sure.
can hear you?
Is that better?
There you go.
We're local business owners. We're very active in our church and community. We became certified foster adoptive parents back in 2016. And two of the main drivers for becoming foster parents, number one, we felt like we were called by faith after participating in a mission trip to Costa Rica, where we spent a significant amount of time at a children's orphanage, and then coupled with years of experiencing infertility. And so we decided collectively we wanted to open up our home. So we did that. If we fast forward to present day, I recently learned of the Landrys, another set of foster parents who are in the audience today, and strikingly similar stories and experiences when it came down to their children. And so I know that there's a lot of matters on the agenda today before the committee, and so it is our hope that we'll be very clear and concise about our experience. And I'd like my wife to share a little bit about our story, and I would like to conclude by citing some case-specific material as it relates to our children's advocates through this experience, and be able to tie that back to the bill that we support and are advocating for today.
Hi, good morning.
Good morning.
As he said, we started fostering. We received our first placement. It was actually, thank you. It was actually a sibling set, and they were two siblings of four that got taken into custody due to severe neglect and other reasons. So we ended up taking the two smaller children. They were, I'll name them as daughter and son. They were 9 months old. Son was 9 months old. Daughter was 4 years old. She had experienced significant amounts of trauma, and then she was also just taken from her two older siblings who she was also close to. So I know we don't have much time, but we spent 2 years in psychotherapy with her, doing play therapy with actually Dr. Charles Zena, a very renowned psychiatrist, was actually head of our case. And they were helping us get through those tough times, severe tantrums, learning disabilities, and many other things like that on the daughter's side. On the son's side, it was hard for him to attach at first. I had to grow a motherly attachment. He was used to probably being taken care of by the older children. He had some health issues. We worked through all that. We spent 2 years of our lives just pouring into these children. I do have a teenage daughter as well. She helped us. She was great with the kids. Sorry. At the end of the day,
take your time. Take your time. Take your time.
At the end of the day, when I printed this bill out, and the main thing I highlighted was regarding the emotional well-being of the children, and just DCFS, I know that they are swamped, they are overworked, there's a lot going on there, but putting into law these things that are listed in this bill are detrimental to the well-being of the children. We had some family members ruled out right away. Mother had mental illness. She even was not allowed to visit the kids after a few months. The baby's dad was unknown, and our daughter's father was incarcerated for a few years. Going through the entire case, there's nothing on record stating that they were trying to locate the baby's father. There's no record of them asking the teenage children, who was your mom dating? What was going on? Did anyone come to the house? So these children took to us. She called us mom and dad on the very first day that she entered our home. That's what she needed. You know, we discussed it with the psychiatrist. She said that she's telling you what she needs. And we were the only parents that he had ever known. Now, we come up on a year. This baby has no other parents. He doesn't know we're not his biological parents. I'm just trying to paint a bigger picture here. All of a sudden, at that year mark, we find a possible father, no record of how that was found, who came and told them this information. That father was incarcerated, and that father was allowed a case plan from prison after 12 months of the child already being in care and multiple therapists saying that we're his psychological parents. And we were already to the point of adoption for both children, both siblings. So as you can imagine, and we are all for the Quality Parenting Initiative Act. We fostered another child who we are still 3 years later best friends with his father. He comes to our holidays. This is about the children. This is about their emotional well-being. This is about the child then being ripped away after 2 visits with an out-of-state aunt to go live with her. This child had nightmares for months, behavioral issues in daycare, which we know of from different things that the family member had mentioned to people in the court or, maybe a social worker. And not to mention that our daughter was never taken into consideration. A daughter who had severe trauma previously before entering our home was traumatized again by becoming an only child. She went from a sibling of 4 to an only child. And these are the things that are put into law here that really need to be considered. We are all for biological parents, like I said. If that is a good situation and that is in best interest, but at the end of the day, our judge stood up and said he thought that he should come home with us, and he didn't know that he had the jurisdiction to send him home with us. It was really disheartening. We then filed an appeal, and the story goes on and on for the last 3 years. So this has been 5 years total, and I still have not been able to tell our daughter that he's not coming home because she prays every single night that her brother is going to be able to be back with her. So just speaking to this bill and the emotional well-being of the children, that's why we did this. That's why no matter what happened, we're still sitting here today, because the children are the reason. And when the Landrys came here the first time to present their case, I could hear it in your voice. You care about the children. You care about these bills. There just needs to be something in place where they're looking harder. After 12 months, they wanted to then bring an aunt back and see if she could adopt them after we were already going towards adoption. These things just shouldn't take place, and it's not about us at the end of the day. We did this to help as many children as we could, and we're not going to stop there. This is the first step in continuing to do that. And I just really appreciate all of the hard work that everyone has done on this bill and the courage that the Landrys and other foster parents have to come forward. There's some people who are scared to death to say anything. So it's very imperative for the well-being of the children that this bill passes, and I appreciate you giving us both the time, and I know he just wants a few more minutes.
Sure. You did a great job.
I really appreciate it. Thank you so much.
You did a great job.
Thank you.
Yes, sir, Jonathan. If you'd like to speak, now would be the time.
That's sort of our short version of our experience.
Very short.
What I like to do is just take a technical approach to some of the things that were advocated for our children through the process of the first 12 months.
Mr. Murray, can you, the mic a little closer. There you go.
There we go. At 11 months, our kid's social worker wrote to the court addressing all parties that our daughter, MB, and our son, JB, remain placed in a certified home of the Murrays. This is the least restrictive, most family-like setting available for the children. The children feel as if they are a part of the family. JB only knows the Murrays as his parents, and MB counts on the Murrays to provide her with much-needed emotional support. The Murrays are willing to adopt should they become available, as at 11-110. At 12 months, as Rebecca stated, the potential father comes into the picture. The court orders DNA tests, which takes a couple of months. And then upon learning that the DNA test is a match, the court awarded the bio father automatic rights to work a case plan, which was promoted by basically the policy, right? The law that they thought was sort of in place. And so, again, I spent almost 2 years in therapy sessions with TPEP and Dr. Charlie and his team. And so in learning about the policy to separate our children and to ship JB away to an unknown relative in Texas, TPEP writes on behalf. And this is the statistics. This is the data that we talked about earlier. The department has informed us of JB's biological aunt who lives in Texas and has come forward and would like to have custody of JB. The department is moving forward with visits and awaiting the ICPC for the aunt, and has informed us that the agency will be recommending that JB move to his aunt if there are no concerns with the ICPC. TPEP states, we are opposed to moving JB to his aunt's home in Texas. Javier has been living with the Murrays since September of 2016 when he was 9 months old. He is currently 25 months old. The Murrays are his only parents that he knows, and it would be detrimental to his well-being to remove him from his psychological parents. JB has been doing very well in the Murrays' home, and they are committed to adopting. In addition, JB has been placed with his 5-year-old sister, who he since was taken into care with. He is very close to his sister, who would be remaining with the Murrays. We believe it would be, again, very detrimental to JB and his sister's well-being to separate them. Should the department continue the visits with the aunt, we would like to be involved closely and would like to conduct a prospective caregiver evaluation with her. In addition, we will provide a detailed transition plan to be implemented if DCFS decides to move forward with the transition against our recommendation. That was the first letter. Our son was taken away from us and his sister in February of 2018. This is the second letter addressing
Mr. Murray, who was the letter from the original one?
Dr. Charlie Zena.
Okay, thank you. Thank you.
And this is 1 month prior to JB being removed from our home. Again, we are writing in regards to MB and JB. As you know, they enter the care due to neglect and lack of adequate supervision. Since the past 16 months, MB and JB have been living with their foster parents, Jonathan and Rebecca Murray. As you know, again, we strongly oppose moving JB to his aunt in Texas. JB has been living with the Murrays since he was 9 months old. He is currently 25 months. The Murrays are the only parents he knows, and it would be detrimental to his well-being to remove him from his psychological parents to send him to strangers. JB has been thriving in the Murrays' home. In addition, he's very close to MB, his sister, who would be remaining with the Murrays, as also the older children, the older siblings, with whom he visits with. We believe it would be very detrimental to JB and his siblings' well-being to be separated. It is our understanding that prior to November of 2017, JB had no contact with his aunt. They have since had 2 visits together, which have reportedly gone well, yet it would not be in JB's best interest to have a presumptuous move out of state to an aunt with whom he has very limited contact, especially following all the turmoil in his life. From JB's perspective, this will create an unnecessarily frightening transition to a new caregiver situation. So that was the second letter. Ten days before we go to the hearing, when JB was essentially awarded custody to the aunt from DCFS, our children's attorney writes to the court, JB was born on said date. Gestation calculator would place conception at the end of February or March of 2015. She goes on to address to the court that the bio dad, who's now come into the picture, was arrested, and I'm not going to go into all details to belittle, but charges of suspended driver's license, marijuana charges, firearm charges, felon in possession with firearm, counterfeiting felony convictions, crime of violent domestic abuse, battery via strangulation. It goes on to spell out the many times that he was arrested between the time of JB's conception to the time that he was born and thereafter. And again, that was 10 days prior. 7 days prior, the kid's CASA worker writes a report to the court ahead of this February 27th hearing. At this time, 7 days prior, our kids have been in care 895 days. States, all of the children are living in safe and secure environment with their foster families. Whenever questioned about them having any desire to return home with their mother, none expressed a desire to do so. Advocate, children's CASA worker, expresses concerns about bio dad's desire to relocate JB to his sister or aunt in Dallas. The CASA worker feels that moving a child from his foster family, no matter the age, is traumatic, but moving him away from his siblings and the only stable home life that he's known would be an additional trauma in his young life, not to mention the trauma of the others. Losing their baby brother to be placed so far away. It goes without saying that 7 days later, it was determined by the case law, the very case law that we're talking about today, that the judge granted custody away from DCFS and awarded it to the aunt in Texas. And I'd like to wrap this up by sharing the last two parts of that. In that hearing, which I was not able to sit at the table with all the other parties that are advocates to the children, even though that I've been raising them for almost 2 years with my wife. Same CASA worker who just recently reported stated that my biggest concern is that I deal a lot with children that have been through transitions and multiple placements. And has MB, our daughter, been made aware of the possibility that her little brother? Judge cuts her off and says, I don't believe so. Talking to the point of, is she aware that he's about to be leaving today? Later through that same discussion, the CASA worker asked, when is JB moving? And the court responded, today. Today, MB is not going to get to go. And the court responded, I have no control over that. At that point, I was just dumbfounded. With everything that I've presented to the committee today, it was present, it was relevant. It was never brought up to promote the best interests of our children, of their relationship. I objected. And I'm not going to go through the whole dialogue, but basically poured my heart out. The judge responds, sir, speaking to me, as I said, if it was up to me, he'd be going home with you right now. I don't think the law allows me to do that. Goes on to say, I can only do what I'm given authority under the law, and I feel sorry for you. And as I said, I think it's in the best interest of the child to be with you. Goes on to say, because the problem is the law doesn't allow that. It's the one thing I don't have control over is what the law says, and that's what I'm sorry about. I know it's horrible for you, it's horrible for me, but that's the one part of the law. I can't control it. I have to enforce the law as it is written, which I can appreciate. However, not in our circumstance. Now, I can tell you that I disagree with the law in this particular point. I think there should be something when a child has been in foster care that no matter what, when his parent steps forward and has the right to, that can be taken into consideration. That a transition or anything. But the problem is nobody filed a petition against the father because they do not have any allegations against him, which means I don't have a right to intrude in his life or his parental decisions, and that hurts you, and I think it hurts the child. I think it's hurting everyone at this table, but the law does not allow me to do anything other than that, and I'm sorry. So at that point, our hands were tied behind our back, and we decided that it was in the best interest of our children to retain an attorney to fight for their rights, to promote what we're doing today before you. And I just have one last thing. Within that period leading up to that hearing and shortly thereafter, when we established that we wanted to fight for our children, that we didn't feel like justice was delivered in their case, we were threatened that our foster certification would be taken away. We were threatened that they would not allow the adoption to go through from our daughter, MB. So we met resistance with resistance, and we proceeded. And it took 8 months for our appeal to be responded by the upper courts. And following that, it was a favorable ruling in which said that the judge had already arrived at a best interest opinion and that he had jurisdiction over the matter, which changed everything. It was a game changer. But he had to take the last 8 months that he was away from his sister and our care into consideration and ordered evaluations be done. And this is one of the last things I'll address. It's a report by Dr. Charlie Zena in reviewing that evaluation. And it's 5-6 pages. I'm not going to bring you through all of it. States to the court that Dr. Dickinson's report, she was the lead expert to do the first evaluation, testimony provided an abundant evidence that both families meet and exceed the minimum standard of being willing and able to provide safe and effective parenting. In addition, Dr. Dickinson documented an express willingness by both parties to allow and encourage an ongoing relationship with the non-custodial partner. Therefore, in this case, the consideration for the court is in which placement JB can be better expected to thrive psychologically, physically, socially, and educationally. On all accounts, it is my opinion that the Murrays are committed to his long-term well-being. They have never wavered since we first met them, and we've had ongoing regular contact with them, mostly weekly up to present. If JB were to be returned to the Murrays' care, the risks to the mental health and psychological well-being are minimal, in my opinion. Given his sustained attachment to them, despite severe and prolonged threats to it, he would be returned to his caregivers.
Just to be clear, this was after 8 months of us not seeing him at all. And they did in-person evaluations.
After the 8 months, yeah.
Correct.
And secure attachment relationships rather than the uncertainty of a new relationship. Being cared for by what Dr. Dickinson acknowledged to be his psychological parents would also buffer him from all potential ill effects of the reduction in contact with his aunt. And I'll fast forward here and hit some of the high points here. This was never questioned by TPEP, DCFS, or by CASA. This is a warm, enjoyable, and fully engaged relationship that seems more than satisfying by both partners. The amount of mutual delight that Mom and JB share was quite striking. We also observed Mr. Murray and JB many times and were impressed by their closeness and Mr. Murray's devotion to him. Amazingly, despite extraordinary limited contact, the 8 months, consisting of brief FaceTime contact, one brief in-contact visit, and one weekend visit, JB clearly maintained an attachment to Mr. and Mrs. Murray through the assessment by Dr. Dickinson. This is virtually unheard of in children in their third year of life because attachment at that age typically requires regular and sustained actual contact be sustained. JB at 27 months of age had absolutely no ability to understand why he was taken abruptly from the Murray's care, nor why he could not see them, but only on the phone. The court should note that in my many years of observing and researching attachment in young children, this is the most extraordinary example of sustaining of attachment relationships by a young child, despite a prolonged separation that I've ever seen. Lastly, it is a testament to the power and importance of the attachment that he has to the Murrays, that he has maintained a strong and healthy attachment relationship to each of them separation. So to bring that back to the bill that's before you. In our particular case, we don't believe that there was enough done to press and enforce the ongoing issue of locating distant relatives. And when it was discovered, it was automatically granted a case plan when mere biological rights does not automatically grant paternal rights. And that was granted, right? And aside from that, the burden was on us at that point to disprove everything thereafter, right? And there was no additional follow-up there. We later found out that by subpoenaing jail calls, that the father in question, who was granted the case because he claimed he didn't know, and that, again, that's another matter that's before you guys today. It was determined in jail calls that the bio mom told him about his offspring, not only him, but was on a three-way call with him, the aunt, and the grandmother. All of these things went before. Unfortunately, my wife mentioned that we've been doing this for 5 years. Our fight has been for 5 years. And as of last Friday, this past Friday, our case is concluded. And then it's so hard to continue this effort, to know that we still have to go back and face our daughter, to know that we fell short again in bringing a resolution to them two being able to grow up together. And so I hope in sharing our experience and then some of the facts surrounding the data, the science, the advocates that are being appointed here, that this new bill would receive your guys' blessings. Because I believe it. We believe it. And we think that it can positively impact future families and children in the future. Thank you.
Thank you both for your testimony. And as Senator Luno said earlier, that thank God there's compassionate, loving people like you. And your testimony helps us to put some clarity to the bill and the necessity of the bill. We truly, truly appreciate you sharing everything with us. It took a lot of courage, and thank y'all so much. And I see there's comments or questions by Senator Mizell.
Thank you, Mr. Chairman. God bless y'all. God bless you. I think your pain was felt by everybody in this room today. I have, my daughter has 5 kids, and all I could think about was the siblings being separated. And that was just beyond my ability to grasp. And I know it's painful, but I think I want to know where those siblings are. Do you?
Yes.
What was the thought, or were you given a logic? And well, I know we'll have people coming up, but what do you know about the way the siblings were broken up?
So the 2 older siblings, we actually still hang out with them. We do laser tag dates and things like that. They've been
Great.
adopted by another family that actually live in the area as well.
Do they live together?
Yes.
Okay.
The 2 older live together, and they're 13 and 17 at this stage, I believe. So they are together. They were adopted. And like I said, in our case, we were expected to adopt them by the first 30-day family meeting. Their mother has severe mental illness. And everyone advocated for us to do that. And, just all of a sudden one day, things changed. And it was just very unfortunate, like you said, to all the children.
So the two older siblings are with a foster couple
Who adopted them.
who was
Correct.
able to adopt them. So their fathers were never found, or there was no biological
The
attachment.
three older children have the same father, and the baby had a separate father.
Okay.
He actually signed his rights over, and we all adopted at different times, the older children.
So JB is the only one that.
Correct. His dad was unknown through this entire time up until, really unknown until about 17 months into care.
And your belief is this bill will allow that not to happen again.
My belief is that this is a very strong step forward and that will, have these laws in place in order for them to say on record, just for instance, we've interviewed the two older children on these dates, and these dates to see if they knew who mother was dating when JB was conceived, or who was coming to the home, or anything along those lines. I feel like it's very detrimental that these things are not overlooked, because then you have cases where children are emotionally traumatized when someone pops out of nowhere and then be sent to another state, or whatever the situation could be. So I do believe that this is a very big step in helping to put those things in place, and I pray that it would largely be paid attention to and followed, so these type of things don't happen to children, because at the end of the day, you are all here to protect children. We did this to protect children. And I just, as a whole, I believe this is a good first step.
I really want. Thank you. I just, and maybe Madeline could. I want some assurance that we're putting something in place, and I know Senator McMath feels so strongly about it. That we've put safeguards in. Are you nodding at me? Yeah. Okay. Thank y'all. God bless you.
Thank you so much for
Thank you.
giving us the time today. We really, really appreciate it.
Thank you. Y'all touched our heart. And I guess the last thing is, we have a tremendous staff of attorneys in the Senate and in health and welfare, and all of us work really closely with the agencies, and we respect the work they do, but no one should ever be threatened to lose any kind of certification. So if you do have an issue, please feel free to call us, because I will tell you, there's so many good people that work at DCFS, and if there is something we can help you with, that's a lot of what we do is constituent services. So don't hesitate to call on those type of issues.
Thank you
Thank
for
you.
saying that. We really appreciate it, and we will pass that word around.
Thank you.
So, thank you.
Thank you. Our last couple that would like to testify is Jacob and Courtney Landry. The floor is yours, and once again, thank y'all, Jonathan and Rebecca Murray.
Thank you.